Imagine a scenario where your country sells off its most valuable natural resource, but the foreign government buying it makes 4 times more money just by taxing its arrival than your own government makes from digging it up.
Right.
That is not a hypothetical. It is the exact mathematical reality currently operating right now in Australia.
Yeah, and welcome to this briefing. Our objective today is singular. We are systematically dismantling the illusion of a functioning democracy.
Exactly. We are here to examine the empirical proof of a structurally hostile state. We need to expose the mechanical, predatory relationship that operates between the Australian government and you, the individual.
Because what we are undertaking today is a forensic audit. We are looking at systemic corruption, regulatory capture, and the architecture of what is known as the attrition economy.
Right. We have to strip away the public relations apparatus of the state and look strictly at its operational mechanics.
Spot on. And when you do that, you find an absolute empirical truth. Moral arguments and public advocacy do not drive systemic reform. Look, the state is structurally immune to your moral outrage.
I want to start by looking at that macroeconomic reality. Because if we want to understand our powerlessness as individuals, we have to understand the dominance of concentrated capital in Canberra.
Yeah.
Let's unpack the math on that natural gas statistic, because on its face it sounds fundamentally impossible. How is a foreign government extracting more wealth from Australian resources than Australia is?
The disparity becomes undeniable when you audit the Australian liquefied natural gas, or LNG, industry. The figures reveal a severe economic paradox.
Right.
It effectively defines Australia as a captured petrostate. Just consider the extraction mathematics. The Japanese government currently collects approximately $8 billion annually simply by levying a tax on the import of Australian gas.
$8 billion?
Yes. And the Australian government, by stark contrast, collects a mere $2 billion from exporting it.
So we are surrendering our own finite national resources.
Yeah.
We are dealing with the environmental impact of extraction. And another nation is deriving 4 times the financial benefit.
Exactly.
How does that compare globally? I mean, are we just bad at this?
Well, to place this in its proper context, you look at Qatar. They generate an estimated $76 billion from comparable export volumes.
Unbelievable.
Again, Australia collects just 2. And the mechanism facilitating this immense loss of sovereign wealth is completely legal. 56% of Australia's gas exports attract 0 royalties.
Wait, 0?
0 royalties. That means more than half of this finite resource is shipped offshore without the extracting multinational corporations paying a single cent in state royalties.
How does the government possibly justify that to the public? We hear constant debates about budget deficits, funding cuts to hospitals and schools, yet billions in potential revenue are simply legally waived.
Right.
What is the actual accounting trickery happening here?
Look, the ultimate absurdity is found in the Petroleum Resource Rent Tax, or PRRT. It is technically a profit-based tax.
Okay.
However, the system is engineered with massive deduction loopholes and uplift rates. Corporations can write off their exploration and infrastructure costs, and they carry those paper losses forward year after year.
So they just legally erase their tax liability before it ever registers on the books.
Exactly. To put the scale of this failure into perspective, in a single financial year, everyday Australian taxpayers pay roughly $2.7 billion in beer excise.
Right.
The PRRT raises just $1.5 billion from the entirety of our offshore gas operations.
The public pays more tax for drinking beer than multinational corporations pay for draining the continent's offshore gas reserves.
Yeah.
That completely shifts the paradigm. I mean, we have to stop viewing the Australian government as a broken democratic instrument.
Because it isn't broken.
No, it is a perfectly functioning corporate asset.
Exactly. It is a functional asset managed through systemic dependence. The major political parties rely heavily on fossil fuel donations.
Right, which are channeled through peak bodies like the Business Council of Australia and Australian energy producers.
Spot on. But the primary mechanism of this capture is the revolving door. We routinely observe former political chiefs of staff moving directly into advisory roles for state-owned oil companies.
Yeah, we see former senior advisors to the opposition leader joining major lobbying firms. They do not leave government.
No, they simply cross the street and monetize their operational knowledge of it.
So if the legislative branch is utterly captured by this corporate leverage, my first thought as a citizen is, well, I will take them to court.
Right.
We instinctively turn to the judiciary because we assume the courts exist as the ultimate safeguard against government overreach.
And that is the intended democratic illusion. But the reality is the courts are engineered to provide structural immunity to the state.
They protect the House.
Always. The legal system is a fortress designed to protect executive power, not to enforce human rights against it. We see this mechanism of judicial deference exposed perfectly in the domain of climate litigation.
All right, specifically the Sharma case.
Yes, the Sharma case.
Let's walk through the mechanics of that, because this wasn't just a protest. This was an attempt to establish a legally binding duty.
Correct. 8 young Australians initiated a legal challenge. They wanted to establish that the federal environment minister owed a common law duty of care to protect children from the scientifically certain harms of climate change before approving a new coal mine.
And initially, a single judge in the federal court actually validated this, right?
They did. It appeared to be a monumental triumph of legal accountability. It suggested the state actually had a legal obligation not to mathematically ensure the harm of its future citizens.
But that ruling didn't stand.
No, it absolutely did not. The government appealed, and Chief Justice James Alsop, along with the full federal court, subsequently overturned the duty of care.
And the ruling was explicit. You have to look closely at the justification they used.
Right. The court decided that preventing climate catastrophe is a political duty, not a legal one enforceable by the judiciary.
A political duty?
Yes. They ruled that policy decisions regarding national economics and emissions belong solely to the executive branch. In doing so, the judiciary formally declared itself useless for providing systemic protection.
They just washed their hands of it.
Completely. Regardless of the severity of the impending harm, they defer to the executive's policy choices.
That is a staggering legal precedent. If harm is mathematically certain in the future, the state legally justifies absolute inaction by simply calling it a political prerogative.
Yes.
But what happens if the harm isn't in the future? What if the harm is historically documented, undeniably horrific, and it has already happened?
Well, the structural response of the state remains identical. For the clearest empirical proof of this, we must examine the historical forced adoptions that occurred in Australia between 1950 and 1975.
Right.
This represents the ultimate devastating failure of retrospective justice in the country.
The scale of what happened during those decades is, it's difficult to process. We are talking about an estimated 250,000 Australians directly affected by a systemic state-sanctioned process.
Yes.
Can you explain the specific mechanics of what was actually being done to these mothers and infants?
The violence of the process was administrative and physical. The state sanctioned the unlawful separation of unmarried mothers and their infants. They frequently orchestrated the removal before the placenta was even expelled.
God.
And the mechanics of this abuse included the illegal physical shackling of pregnant women to hospital beds.
Shackling them.
Yes. They systematically administered stupefying drugs to ensure compliance. Authorities utilized dangerous lactation suppressants, specifically a synthetic estrogen called diethylstilbestrol, or DES.
And this was administered without consent.
Entirely without consent. It was frequently given as a massive overdose, simply to dry up the mother's milk instantly so a biological bond could not form.
And it also carried severe, scientifically documented carcinogenic risks.
Absolutely.
Look, these weren't just ethical failings. These were massive, undeniable breaches of existing criminal law. They violated the Commonwealth Marriage Act. They violated the Crimes Act.
Right.
So why weren't the perpetrators prosecuted? How were they shielded from any legal consequence?
They enjoyed complete structural immunity provided by the architecture of the law itself. Criminal prosecution for these atrocities was systematically blocked by evidentiary decay.
Meaning the records just disappeared.
Yes. Hospitals and state departments simply allowed the necessary medical records and consent forms to vanish or rot over decades.
Unbelievable.
And when the victims attempted civil litigation for negligence, for the profound, undeniable breach of a duty of care, they were nullified by rigid 3-year statutes of limitation.
So the courts essentially said, yes, you were unlawfully shackled, drugged, and your child was taken. But because it took you more than 36 months to overcome the trauma and file a lawsuit, the state is no longer liable.
Precisely. The courts offered zero structural remedy. The legal avenues were decisively closed.
Right.
The burden of proof was placed entirely on traumatized, disenfranchised individuals. Meanwhile, the state possessed all the institutional power to simply wait out the legal clock.
So with the legislative branch got by corporate interests, and the courts effectively closing their doors through statutes of limitation, the state forces the citizen into an endless, agonizing battle of endurance.
Yes.
And this is an accidental failure of the system. This brings us to a calculated policy choice we need to define, which is the attrition economy.
The attrition economy operates on a tactic known in sociology as strategic default. The state deliberately ignores demands for redress.
They ignore recommendations from their own inquiries.
Exactly. And they ignore pleas for intervention. They do this because the political and financial cost of doing absolutely nothing is mathematically lower than the cost of taking action. The institution weaponizes time.
It's an accounting strategy. If you ignore a traumatized group for long enough, members pass away, the momentum fades, and the eventual payout is minimized.
Spot on.
And this attrition economy is sustained by an invisible psychological baseline within the government, correct? A concept defined as kept privilege.
Yes, kept privilege is the structural immunity of the bureaucrat. The policymaker in Canberra views their own unbroken lineage, their unchallenged identity, and their continuous employment as a passive asset.
They inhabit a default state of institutional continuity.
Right, because they do not have to fight simply to exist within the system. They view the trauma, the displacement, and the suffering of everyday citizens merely as an externality.
It is a cost that happens out there to someone else. It does not register on the state's operational balance sheet.
Precisely. And to truly comprehend the gravity of kept privilege, you have to measure the speed of capital against the speed of trauma.
Right. How fast does the government move when money is threatened versus when human lives are destroyed?
The contrast is completely empirical. When the gas lobby is threatened by a proposed tax adjustment, they deploy millions of dollars. They activate former political staffers now working as lobbyists.
And they kill the proposal within a single budget cycle.
Exactly. The state's response to capital is immediate. Now compare this to the timeline of trauma. Look at the victims of forced adoption. Grassroots organizations like Origins Victoria and the Association of Relinquishing Mothers, or RMS, they began engaging in relentless, re-traumatizing lobbying in the late 1980s.
And it took them decades.
Decades. It required over 20 years of sheer attrition just to secure the 2012 Senate inquiry into the practice. And it was not until 2013 that Prime Minister Julia Gillard finally delivered the national apology.
Over 30 years of bleeding in public, reliving their worst nightmare in parliamentary committees just to secure an apology.
Yes.
This dictates the brutal economics of an apology in Australia. Grassroots movements only succeed when the issue crosses a threshold of undeniable moral imperative and, crucially, when it carries absolutely zero ongoing economic cost to the government's corporate donors.
Spot on. The endless consultation phases, the performative apologies, they are precisely designed to wait out the biological and psychological reserves of the victim.
Because if the state can exhaust you, the administrative record remains unchallenged and no financial compensation is required.
Exactly.
The ultimate proof of this attrition economy is found in how the state deploys its highest investigative weapon, which is the Royal Commission.
Right.
We are taught that a Royal Commission is the ultimate truth-seeking mechanism. It has coercive powers to compel evidence, seize documents, and expose systemic failure.
But if we look closely, they are inherently political instruments, aren't they?
They are. They are entirely political. The government writes the terms of reference, which means they decide exactly what is allowed to be investigated and what is structurally ignored.
Yes.
Yeah.
The state utilizes narratives of international commitments and national security to frame who gets investigated and who operates with absolute impunity.
Let's look at the banking sector. We had a massive Royal Commission into banking misconduct. Executives were dragged in front of the cameras. Why did the banks face scrutiny while other sectors don't?
Well, the government initiated a royal commission into the banking sector because the public outrage regarding foreclosures and dead people being charged fees became so severe that politically protecting the banks became toxic.
Right.
But the critical structural factor is this. Penalizing the banking sector, forcing them to pay fines or alter their compliance, did not threaten the core revenue models of the state.
It did not dismantle the primary funding mechanisms of the major political parties.
Exactly. Now, contrast that with the total immunity granted to the gas industry. The public outrage over the Great Gas Scam is massive.
Yeah.
Everyday citizens are being bled dry on domestic energy prices.
Small businesses are collapsing under power bills while multinational gas profits soar into the billions.
Yes. And the expert consensus demanding intervention is absolute. The Superpower Institute publicly proposed a 40% levy.
Right.
Former Treasury Secretary Ken Henry demanded a 100% windfall tax, stating bluntly to a parliamentary committee that the government should just do it and stop the crap.
Yet there is zero political will for a royal commission into the gas sector.
Zero. Federal opposition leader Angus Taylor defended the industry's current operations by stating that even a 25% levy would, quote, kill the sector.
So why the total immunity? Why is corruption and price gouging tolerated there but investigated elsewhere?
Because a royal commission into the gas sector would require dismantling the very financial mechanisms that underwrite both major political parties.
Right. The fossil fuel industry effectively funds the operational costs of the political system during election cycles.
Exactly. You cannot launch a coercive royal commission into the entity that pays for your political survival. This is why structural integrity in Australia is constantly undermined by design.
We see this with the National Anti-Corruption Commission, the NACC.
Yes.
It operates with severe structural flaws, predominantly holding its hearings in secret, which protects the reputations of public officials over delivering transparency to the public.
Spot on. We also see this in the South Australian ICIC report, which explicitly detailed the dangerously opaque nature of lobbying. It proved that privileged, undisclosed access to decision-makers fundamentally compromises public administration. When you don't have to declare who you are meeting with, systemic corruption is simply rebranded as industry consultation.
So we have established that the legislative branch is bought, the judiciary is blocked by statutes of limitation, and the investigative bodies like royal commissions are politically weaponized to protect state revenue.
Yes.
Recognizing that the state is an impenetrable, structurally immune fortress, what is the citizen supposed to do? Because moral pleading is clearly a void currency.
You must fundamentally alter your strategy. The friction you carry, the exhaustion, the trauma, the financial loss, it must be forcefully transferred back to the institution.
We define this tactical pivot as forensic inversion.
Yes.
How does forensic inversion actually work in practice?
It requires shifting the cognitive and administrative load away from the victim and forcing it onto the state. Moral appeal must be systematically weaponized into institutional risk and regulatory breach. If the system only responds to institutionalized pressure and financial leverage, the public must adopt the exact mechanics of the institution. We observe this tactical evolution perfectly in the rise of a movement called punters politics, led by Conrad Benjamin.
Benjamin built a massive digital following, nearly 1 million Australians, strictly by exposing the realities of the gas taxation regime we discussed earlier.
Exactly.
1 million voices crying out for change. But in the attrition economy, digital reach means absolutely nothing.
Digital reach is structurally meaningless because access to power is entirely transactional. This was proven empirically when Benjamin attempted to attend a major gas lobby conference in Perth.
Right.
Despite legally purchasing a $3,000 ticket, he was flagged and denied entry at the door.
Just turned away.
Yes. The physical doors of policy influence are closed to the public, regardless of their financial capacity or their digital capital, unless they operate strictly within accepted corporate pathways.
So the tactic had to evolve. If we cannot break the machinery from the outside, and we cannot shame the machinery into changing, we have to purchase the machinery.
That was the realization. In November 2025, Punters Politics executed a political fundraising dinner. It was a deliberate structural subversion of the corporate pay-to-play model.
They crowdfunded the resistance.
Yes. The public crowdfunded $80,000 to hire Rachel Smith, establishing her as Australia's first ever citizens lobbyist.
Explain the significance of that. Why is a citizens lobbyist fundamentally different from a protest leader or a petition organizer?
Because Rachel Smith was deployed directly inside Parliament House. She did not stand on the lawn with a megaphone.
Right.
She utilized the exact same registered corporate pathways, the exact same security passes, and the exact same bureaucratic language as the fossil fuel lobbyists.
She used their tools against them.
Exactly. She was there to advocate on a publicly funded mandate for a 25% gas export levy. This is the critical transition of forensic inversion. It transforms sporadic, easily ignored grassroots outrage into permanent, professionalized institutional friction.
She books the meetings, she submits the policy briefings, she tracks the legislation.
Yes.
We're no longer acting as victims of a broken system pleading for help. We are acting as forensic auditors of a liable system.
Spot on.
Inaction must be made more administratively and politically expensive for the bureaucrat than compliance. If ignoring the public costs them more friction, more paperwork, and more institutional risk than doing something, the machinery of kept privilege finally begins to fracture.
The deployment of a citizen's lobbyist provides the empirical proof that systemic corruption cannot be defeated by legal action constrained by statutes of limitation, nor by public advocacy designed to be exhausted. It must be countered by mirroring the exact tactical deployment of concentrated capital from within the legislative framework. Until the structural immunity of the state is breached by equal and opposing institutional force, the attrition economy will continue to function exactly as designed.
You exist within an architecture of indifference. Let this reality settle. Your moral outrage, your digital petitions, your belief that justice is an inherent democratic right, these are entirely void currencies in Canberra.
They mean nothing.
The state does not hear your suffering. It only registers your leverage. Change is never a gift of democracy. It is a calculated extraction from a system that can no longer afford its own silence. You must force the friction.
Exactly.
So we leave you with a chilling structural dilemma to analyze on your own. When you finally mimic the native language of capital, when you crowdfund your own lobbyist, navigate the revolving doors, and purchase your rightful seat at the table of power, do you actually dismantle the machinery of kept privilege? Or do you simply become another stakeholder managing its profits?